Hi there, I'm Savannah Mexto with Manor Law Group, and I'm excited to welcome you to another webinar Wednesday with esteemed elder law and estate planning attorney, Robert Manor. On today's webinar, Bob will be shedding light on a new act recently passed by Congress and what it means for you, your retirement accounts, and your estate plan. If you have a 401k and an IRA, this webinar is especially important for you. Now, before I pass the torch to Bob, I'd like to cover a few housekeeping details. Now, first, a quick disclaimer, and Bob will cover more on this later, but today's webinar is going to be informative, educational. You'll definitely walk away learning something that you didn't know before, but you're not going to receive legal advice. If you are looking for legal advice or something specific to you, then I encourage you to contact us after the webinar, and we can take care of that later. Now, also note that today's webinar is recorded. You will get a replay link later this week, most likely tomorrow, that you can watch again anytime and then share with family, friends, or anyone who you think could benefit from learning this information. If you have a question at all during today's webinar, I encourage you to use the chat box. Please put your questions in the chat box because we will save time at the end of today's webinar to answer those questions. And if for some reason we don't have time to get to your question that you left in the chat box, we will reach out to you after the webinar. Now, why should you listen to what the folks at Manor Law Group have to say? First, you should know that we're a nationally recognized and respected elder law and estate planning firm. All three of our attorneys are accredited by the Veterans Administration to assist veterans with claims and appeals. Attorney Bob Manor is nationally board certified as an elder law attorney by the National Elder Law Foundation. He's one of only 19 attorneys in Michigan to achieve this designation. He is currently on the executive board of the State Bar of Michigan Elder Law and Disability Rights Section and past president of the National Academy of Elder Law Attorneys, Michigan chapter. Lastly, one of my favorite reasons, Manor Law Group has been honored by readers of our local paper as the best or favorite law firm for the last 8 years in a row. Now, without further ado, I'd like to welcome attorney Bob Manor.
Hi, folks. I'm glad you're joining us for this presentation today. I know that there's been a lot where most folks are just kind of focused on the whole virus situation, and so it's difficult to kind of shift gears into some financial information. To be honest with you, if you would have asked me what we were going to be focusing on mostly in 2020, it was going to be the Secure Act and how it's going to have an effect on your retirement accounts. And so we've had to obviously put this on hold a bit. We would have probably rolled this out to you a little bit sooner, but there was a few intervening things that came up in between times. But it is now, as much as there is lots of things going on in the world, it's important that we address this. There's been a few times in my career where there's been such a significant legal change that most people's legal documents need to be brought up to date. And this is one of them. I remember, and I was much younger attorney back then, but back when the HIPAA laws passed, the healthcare privacy laws passed, and pretty much everybody's documents had to become compliant with HIPAA, the healthcare privacy law. And this doesn't quite rise to that level, but it comes pretty darn close. If you have retirement accounts, if you have a 401k, IRAs, qualified annuities, PSP, 457, any of the accounts, often with folks that are older, I'll say, if you have any accounts that have required minimum distributions, that's a retirement account, and that's what this affects. Or Roth accounts also are highly affected here. So this is a pretty big deal, and what's interesting is it really flew under the radar. I think my suspicion is even with some politicians, because when I talked to politicians about this, a lot of them were, if I mentioned the Secure Act and my concerns about it, and there's some really good things and there's some things that are going to be a bit more challenging, but it also, every time that there's a law change that makes things more challenging, there's also opportunities for those that are willing to plan and willing to make sure that they have the proper people giving them advice. And so when I was talking to politicians about this before it was passed, and I was expressing some concerns, a lot of them were only focused on some of the highlights and some of the things that people really like about the Secure Act, that almost universally people are liking about the Secure Act, and they were surprised, some of them, about the some of the consequences of the Secure Act, especially as it relates to retirement assets after you die. In other words, inherited IRAs or inherited retirement accounts. What happens to the account and how is it going to be taxed after you die? So that's going to be the biggest effect, and why we probably need to update most people's legal documents as a result of that. Now, what if you don't have any of those? What if you don't have any accounts that are considered or were 401ks or IRAs or PSPs or qualified annuities or anything where once you turn, now it's over 70, at 72 now, we'll talk about that in a second, but once you turn a certain age that you have to pay required minimum distributions. If you don't have any of those, this actually doesn't affect you. We probably, if you're over a certain age and you don't have any of those and you're not expecting to get any of those, then this probably doesn't affect you. Probably don't need to change your legal document. That's why this is a little bit different or a little bit less universal than the HIPAA law changes, because it only affects those people that have retirement accounts. Now, most of us have retirement accounts, right? So when my dad was growing up and when my dad was in the raising kids and working and all of that, it was extremely common. And what he had is he was working for a pension, right? So he worked for GM and he got he worked there almost 40 years to the day, if I remember correctly. 40 years to the day, and as a result of that, he earned a pension, and so he would get a monthly check. And some of the folks that worked for GM several years ago, they said, "Oh, well, instead of sending you a monthly check, we'll give you a lump sum." And so the idea of that lump sum, that would be a retirement account, whereas the monthly check, that's not. That's a different thing. That's it's considered a defined benefit versus a defined contribution. But the bottom line is, if you get a monthly pension, that this is not affected by it. This is not affected by it. Your monthly pension that you got from GM or from the school district or wherever it is, that's not what I'm talking about when I'm talking about retirement accounts. But as time went by, in my generation, so my dad got a pension, and he also had IRAs, and he also had it was able to contribute to retirement accounts, qualified, what we call, the technical term is called qualified funds. The younger generation often don't get that. I'll never have a pension unless I work for the government, or if I work for a few businesses now still are offering pensions. But instead, what everybody shifted to, in fact, my own office, what we shifted to is what we call a defined contribution. In other words, we contribute, for all of our employees, we contribute every month to their retirement, but not in the form of they're guaranteed a pension that they're going to get this dollar amount every month for the rest of their life when they retire. It's we're putting in this dollar amount, and what they do with it then is up to them. They could turn it into a monthly payment. They could have it as a lump sum. They can wait till they're 72 and take out minimum distributions. But that has been the shift over the last 20, 30 years, that most companies, private companies in particular, don't offer a set amount that you're going to get every month. They contribute to a fund that you then have that lump sum of money. But the thing is, that lump sum of money still has to be taxed sometime. At some point, that's going to be taxed. And so that's what the Secure Act is going to be able to address. And so many of you have dealt with this in your plans. So if you are a client of ours, we would have given you an option. We would have given you an option to say, we want to include those retirement accounts as part of our plan, or we don't want to include those retirement accounts as part of our plan. And you would have had that option. If you're not a client of ours, then lawyers may not have given you that option. A lot of lawyers decided not to get into that tax issue, and they just said, we're always going to exclude those retirement accounts. Regardless of that, though, now going forward, we really need to make sure that your legal documents are going to be compliant with the new rules. I'm going to show you exactly why and how this could really affect you. There's going to be a graph in a second here that's going to show you it could have significant tax difference for your family, for your spouse, for your kids, by sometimes, with some of your accounts, it could be tens of thousands of dollars, it could be hundreds of thousands of dollars potentially if you don't do this correctly, if we don't have this set up correctly. Now, we've always have been planning. This has been a philosophy of mine for 20 years now, that we plan with the idea that laws are going to change. So God forbid, let's just talk about this off the top. What happens if you do nothing? We will, and you come to see us after you die, or your family comes to see us after you die. Can we use the existing documents to avoid the worst? Of course we can. I've always built in that kind of contingencies. I've always built in that kind of options to make sure that we have some provisions in there that we don't get the worst case scenario. There's going to be some outs, some ways to disclaim and things like that. Now, the problem with that is that that's not the best. It's not the worst, but it's not the best. And what I want to be able to do is offer you the best option. Most people, and I'm hoping not too many people get offended by this idea, but most people would rather have more money go to the family and less money go to the government. And that might not be that controversial of an issue. And that's what I'm trying to accomplish. And so if we don't update these documents and you die, I'm going to make sure, or if you come to see me and you come to see our folks at Manor Law Group, we're going to make sure that the worst doesn't happen. But we want to make sure that we also have the option of the best. And it's a really interesting concept of how do we know with what is a relatively complicated issue of taxes and how much money is going to be in your account. Some of you have heard me speak recently where I kind of shifted gears a little bit to talk about, well, what happens when you actually use these documents? So a lot of times when folks would come in, I would give them advice, or one of the folks here would give them advice on how do we set things up. And I've really tried to shift gears and get people thinking about not just how are we setting it up for tomorrow, because I don't think you're going to die tomorrow, and I don't think you're going to become incapacitated tomorrow. So we have to, of course, plan for that. We have to plan for tomorrow, literally tomorrow or next week or 6 months from now. But I want to make sure that we've planned for when the thing happens. Well, when is the thing happen? What do I mean by the thing? You become severely incapacitated or you die. That is the thing. So when is that going to happen? Now, here's the key question. And a few of you have heard me say this. I've started shifting my conversation a little bit to what is the key question that I'm going to ask the family or whoever, the executor, what's the key question I'm going to ask when I get that call that you're either incapacitated or you've just died? Now, hopefully most of us don't become fully incapacitated, but all of us are going to die, right? So presumably I'll get that call eventually for everybody, whether it's me or somebody else, but we'll get that call. And so what's the key question? And I've asked that to groups of audiences of clients and others, and what's the key question? I think I brought this up at our annual client meeting last year. What's that key question? And it's not whether you have a will or a trust. And it's not who your executor is. And it's not what document it is. The key question is actually, what assets do you have and how are they titled? And so here's the one thing that is somewhat impossible for me to know now is in 20 years, it's a bit impossible for me to know in 20 years, what assets will you have and how will they be titled? Okay, so that's what I'm planning for. That's the biggest question I want to know. If you become incapacitated and you call me, if there's a crisis, if there's an emergency, if there's a death, obviously I don't just blurt out that question. What assets are there and how is it titled? I have some politeness to me and we'll talk about things, but in the back of my head, when my gears are working in my head and I get that call, the first thing I'm thinking are, what assets are there and how are they titled? And so that's something it's unknowable right now, right? And that's the thing that if I knew that, if we could plan for that, I could have the best tax plan for you. I could make sure we have the minimal taxes. I could make sure everything's going to go as smoothly as possible. It's going to go as quickly as possible. If we knew at the time that that crisis occurred and could plan around it, what assets do you have and how are they titled? Well, of course, this could be 20 years from now. This could be 50 years from now. We just don't know that. And so we're going to talk about that. And this is a really relevant conversation as it relates to these retirement accounts, because that's definitely something we're not going to know as it relates to your retirement accounts. So if you have a Roth, maybe it has just grown and you've not taken anything out of it. That's kind of the idea of a Roth account, is ideally you spend that last, because that's the money that's going to grow tax-free for the rest of your life. And we're going to show you how it can grow tax-free even after your life. And there's some options there that can make it really so that you have an opportunity to pass on money to your family and have less taxes on it, especially with the Roth. But ideally that money just grew. And with other accounts, maybe you spent some of it. Maybe you switched financial advisors and they switched how it was titled. Maybe you switched beneficiaries. Maybe you set up a trust. Maybe you set up these things. And so the idea is, how can we plan for something that is not fully knowable? And there's some really smart people in the audience. I can see a list of the folks here, and there's some really smart people. And some of you might be thinking, well, seems to me, if we want to plan for something that's not fully knowable, we're going to want to plan to have it be flexible and to have options, and ideally to be able to have all the options so that we can choose the best possible setup at the time when we know all the information. So let me repeat that. How do you plan for something where you don't know the answer to the most important question? And the answer is, we make sure that we have the most flexibility and that we create all the options. Well, your existing documents, whether I drafted them or somebody else, your existing documents, your existing legal plan, does not incorporate all the options. It can't, it couldn't have, unless you've drafted it probably in the last few weeks here and had a really talented attorney. Just teasing. But the bottom line is, even us, when we were drafting documents in January, we could not draft them in such a way that it was compliant with this new Secure Act, because they hadn't issued the regulations. In fact, they still haven't issued all the regulations, but we've got enough of it that we're able to draft accordingly. And the idea is, what happened is they passed this law like the last week of December of 2019, or the second to last week of December 2019, and it took effect January 1st, 2020. And so we're gearing up. I had spent the first several months of at least first three, better part of the first 3 months of 2020, thinking this was going to be the focus of my life for 2020. Was dealing with the Secure Act, making sure that we had the best options built in, the most flexibility built in, and that we can not only help the clients that we have and make sure that we bring all of them up to date, but also that we can actually reach out to new folks that maybe their clients are their previous attorney, or they don't have a current attorney, things like that. Maybe they're not as up to date on some of the tax rules and some of the options and some of the flexibility, or just maybe not as creative as some of the things that we're going to be talking about today. So I thought this was going to be a really big push. Of course, then whatever day in March it was that everything shut down, and so as well, I was still thinking about the Secure Act and still focusing on this. We had to make sure that people were just secure, that in their health, and that they had their proper healthcare documents, and that we could help those folks that were in the most danger. And so we had to shift gears. There was no option. I feel like now we're at the point that, well, we're still going to be doing that. We're still going to be helping folks that are in the crisis situations. Actually, just finished a call a couple minutes before we started this webinar on one of those crisis situations. And so, but I think we're ready now to start shifting gears and talking about something that's going to be really important, and make sure that we can build in that you have that flexibility and options to be able to have address and pay the minimum amount of taxes on something that is not fully knowable. It's not fully knowable what you're going to have in your account and how it's going to be titled when you die, which could be tomorrow, or it could be 20 years from now, or it could be 10 years from now. And as we've seen in 2020, just because even if you say, well, it's not 20 years from now, I hear people say this all the time. And I say, well, you don't know that. You don't know that it's not 20 years from now, first of all, because I've seen families that thought that they were, a parent or themselves, that they weren't going to be here in 20 years, and they were here 20 years later. But also we've seen in 2020, things can change so dramatically overnight that we want to build in that flexibility, whether you think you have 20 years left or 5 years or 1 year, 6 months or whatever, we still want to build in that flexibility. So, okay, that was a long introduction, but there's the rest of it won't be too long. We'll probably finish before the hour is up today, but I wrote myself a note to remind myself to say this. So we're going to talk about some details of the Secure Act. We're going to talk about how it affects you now and how it affects your family later. And then I'm going to get into all the confusion. Fun for you, right? There's going to be all these charts and all these flow charts. You're going to see all the arrows going in different directions. I'm going to go through all that confusion. And I'm doing this intentionally because it is confusing. And it's took us, we get really quality people and other friends and colleagues that we've relied on to sort through all of this. And it's complicated. But the bottom line is we've cut through all of that. So what I'm going to finalize it with this solution. So in the middle part of this presentation, if you feel your head spinning, good, that was my intent, because my head was spinning when I first started reading the new Secure Act and how it affects the different situations and how do we plan for something that we don't know the situation at the time. Not only did we not know how much you're going to have and how it's titled, but we also don't know what your family situation is. Has somebody died before you? Does it end up going to a minor child if it went to grandchildren or great grandchildren? Is it possible it went to somebody with special needs or that's disabled? We have all of these possibilities, and the Secure Act deals with each of these things differently. Does it go to the spouse? Does it not go to the spouse? Should it go to the spouse? That's a really interesting question under the Secure Act, is whether it should go to the spouse. So we have all of these things. So I'm going to confuse you because it's confusing. One of the things that one of the best compliments that we get is that we take complex issues and we simplify them. Well, great. I really appreciate that. Well, guess what? This is going to be confusing. And then I'm going to cut through it and say, okay, with all of that confusion, the bottom line answer is this. Here's the solution. Here's the real solution. After we cut through all of that stuff, here's the solution. And the solution is flexibility and having the options to be able to set up the plan in any way possible once we know the facts. Well, when are we going to know the facts? After you die, after you became incapacitated. And so we've got to have your plan so flexible and so compliant with these rules that we have every option available. So we're going to see the flow chart, but you don't have to worry too much about the flow chart. Flow chart's my problem. Okay, I'm going to show it to you so you see all the complication, but then I'm going to say, okay, the bottom line is this. Let's cut through all of that and say, let's say all of the above. All of the above, we can do any of the things on that flow chart, and we get to decide, not now. We don't have to decide this now. We can decide at the time that we know all the facts. And that's the key here. And this is the key that we couldn't totally do before. Under their old rules, they had all of these things about life expectancy and who can be a beneficiary and who can't be a beneficiary. Can you name a charity and can you not name a charity? And if you name this person, it's going to affect the taxes this way. All of that's thrown away. This is what I like about the Secure Act. Actually, a lot of the things which said, well, we've got to make the decision now. Even though we don't know what's going to happen in the future, we got to make the decision now as to how we're going to have the beneficiary designation and how we're going to handle it upon death. We got to make that decision now. Now, under the Secure Act, we're able to say all of the above, and then we'll decide which plan we're going to follow once we know all the facts. Okay, we couldn't totally do that prior to the Secure Act. So there's some bad stuff about Secure Act too. I'll get to it in a second. Okay, so how does it affect you now? How does it affect you after you die? And what do you need to do now? I mentioned that we're going to handle this a little bit differently for clients. In a little bit, if you're a client of ours, and at least if you're in our database in the last few years, we will be reaching out to you. If you've been invited to our annual meeting in recent years, you'll definitely be in our database, and we'll be able to reach out to you. And we're going to give you specific instructions for our clients. So today is about the what, and for our existing clients, we're going to send you a message about the how. Okay, what do you need to do to update this? What do you need to do to accomplish this? That's the what. That's the next message. If you're not a client, then there's going to be a different process, right? If you're already a client, you already have our documents, we know your documents are good, we need to update those documents. We're going to give you options to say, okay, here's the process. We're going to have the process where you sit down one-on-one with us for some advice. They're going to have the option. Some people, they're going to take the position of, hey, just fix it. I don't even want to talk about it. Just fix it. I don't like that option, but we are going to have that option to do it for you. You just fix it. You may be saying you, meaning Manor Law Group. We'll just fix it, and you don't want to know the details. I don't like that option because I like details, and I like you to know the details, and I like to go through and make it even more specific for your unique circumstances. But we have that option of the just do it for you, to sit down, we'll answer all your questions, and then do it for you, and then sort of the luxury package that we're going to have too. So we're going to lay all that out for you. That's the how. Today's about the why. Of course, disclaimer, you can't take any of this and act on it. This is general advice for general public, and so there's nothing going to be in here that you can just say, okay, I'm going to write my own legal documents because of this hour-long presentation that I went to. No, I really think that would be a very bad idea. So I always put that disclaimer in. All right, I liked this graphic I saw from CBS News, really kind of cutting to the chase on some of the Secure Act highlights. One of the big things that, the two big things that were real sales parts for the politicians. Politicians were often saying, hey, this is a great thing, because instead of having this weird formula as to decide when you have to start making required minimum distributions, we're just going to have it be 72. Now there's still a formula. It's actually not. It's a little slightly more complicated than that. But bottom line is it's 72 now. They simplified that a little bit. Used to be that you couldn't make any contributions to your accounts after age 70 and a half. Honestly, I'm not sure why most people would want to. I'm often of the opinion that we should be looking at being strategic about taking the money out and paying the taxes strategic at some point, even before age 70. But I'm sure there are unique circumstances where it really makes a heck of a lot of sense to contribute more even after age 70 and a half, certainly for any Roth contributions. But the big one I want to talk about is this last bullet point, which is inherited IRAs must be emptied within 10 years, except when they don't have to be emptied within 10 years. And that's the key thing here. Okay, so when we first read it and when people first thought about it, it used to be that you could stretch out your IRA payments to your kids over their lifetime, or even the grandkids over their lifetime. And so we could stretch out these payments over 60 years sometimes if we went to the grandkids, sometimes 2 generations, things like that. And so that was good, but complicated because they had all these technical rules. We need to, we have to look at the life expectancy, and depending on how we set it up, is it going to go based on the oldest child, or can we have it be so each individual gets to do their life expectancy? And if we leave it to someone who's older, does everybody have to follow that life expectancy? A bit more complicated. Now, intended to be a little bit simpler to say, look, everything has to be paid out in 10 years, but it doesn't. Okay, that's the talking point, but it doesn't really. And so we're going to talk about some of those exceptions. And so why is this a big deal? Well, if you know that you don't have to pay taxes on something until you take it out, if you can take it out over 60 years, how much more money are you going to earn over 60 years tax-free than over 10 years, right? If you have a Roth IRA, remember Roths are the ones where it's you contribute to the Roth with money you've already paid taxes on. And so if you could have a Roth IRA and stretch that out over 60 years, imagine that. You could have 60 years worth of gain at no taxes. When your grandchild takes it out, over 60 years, they will have taken out so much more money and never had paid taxes. If you get gain, if you put your money in the stock market or investment or whatever it is and it gains, you pay taxes on that gain, right? And so the idea of income taxes is you take it out, not capital gains necessarily. But the idea here is that with the Roth, you never pay taxes on the gain on it, which is really interesting. Now they've limited that to 10 years, sort of. Okay, so that's the overview, but let's start to get into some of the complications. I'm getting slightly more complicated in each slide, okay? So that was the simplest of slides. Now we're gonna get, okay, let's talk a little bit about it. But what about that 10-year thing? So now we've got these things called eligible designated beneficiaries, and we can still stretch with regard to minor children. Okay, it doesn't have to be your children, could be grandchildren, could be nieces, nephews, could be whatever, could be great-grandchildren, but the idea is we can still stretch it to age of majority. What's one question we don't know yet? We don't know what age of majority is. They haven't defined that for us yet. We think maybe it's gonna be 26. We don't know that. They have language in there that's a little bit evasive as far as when can you do 26, when do you do 18? Bottom line is IRS still has to issue some regulations on this, but I'm not worried about that. The way we've drafted it, it's gonna adapt to any of that. Okay. So disabled persons, if we have special needs trust, we can have them be an eligible designation. Chronically ill, more than 10 years younger, has special rules for that. Not more than 10 years younger. Spouses, of course, we can still do the spousal rollovers and certain trusts. What are designated beneficiaries? Non-spouses, certain trusts. This has where the 10-year rule is. This is where that 10 years. So you see, there's 3 different categories here. And so on that previous slide from CBS, they were just looking at the middle. They just assumed everybody was in that middle slide. Well, we got all these other considered eligible designated beneficiaries. Now we've got designated beneficiaries, and that's where that 10-year rule comes in. Here's where it gets dicey. Non-designated beneficiaries. Now we've got a 5-year rule. Between 5 years and 10 years, that can be a big difference in how we're going to get taxed and how much we're going to get taxed, what percentage we're going to get taxed. It really can be a big difference here. And so now we're looking at charities. We're looking at you if it's just your estate, naming it in your will, and certain trusts. So the certain trusts. This is where if we don't update these trusts, your existing trust, even if it's one that we did it, we're going to have options. Now, if we don't do it right, you could end up with that 5-year rule. Now, what we would most likely do is we're going to be looking at, well, can we do it as an eligible designated beneficiary and still have this stretch, or can we disclaim? And so that's why I say there are options, but they're not great options. And the bottom line is we don't want that 5-year rule. That's why this is in red over here. We don't want that 5-year rule. And if you don't do anything, you know, we might be subject to that, or even worse, that it could be, you know, where they're paid out immediately and pay even more taxes. Okay, so now we're getting slightly more complicated, and this is the layered funding decision tree. All right, so I call this the inside planning. What if we're trying to plan for, you know, within the trust? And so the answer is, okay, do we want it to go to the surviving spouse? Well, the answer generally we want it to go to the surviving spouse, right? But then one of the things that we might want to look at is, okay, well, we don't know when the first spouse is going to die, and we don't know what the circumstances of that surviving spouse is. So wouldn't it be interesting if we could say, yes, well, of course we want at least to have the option of having a surviving spouse, but what if at the time, of the death of the first spouse, it actually makes sense to bypass the spouse, both for taxes and for eligibility issues and for planning issues and making sure that it doesn't go to a nursing home or things like that. You know, there's all of these options to say, well, can we have it be where it goes, where we have all those options? Of course, the answer is yes. We can have it set up that way. So then we've got the grant exclusion access, grant access or non-exclusive. We've got all of these different options. We can go to a family trust. We can go to a spousal retirement trust. We can have it go to the spouse directly. Then we have the option of, no, we're going to bypass the spouse. So there could be lots of reasons for that. There could be that there's sufficient assets that we want to bypass the spouse for some portion of the retirement account. Could be that it's a second marriage, and so we want to make sure the spouse is provided for, but also that that it doesn't all go to the spouse and some of it goes to the children of this first spouse to die. And so then we've got this option of family accumulation trust. We've got separate share trust. We got the trust determination. We got all of these different options. We got to look at, well, are they a minor? Are they disabled? Are they chronically ill? Can we do the lifetime stretch? Or do the outright? Now you see all these options, and so some people would say, oh my gosh, Bob, just do the simple one, right? If I have the choice of all of this or all of this or this, I'm going to choose this because it's simple. All right, look, I've had this conversation with folks before. Do we want it to look simple or do we want it to be simple? And so when I say simple, I want simple results. I don't want it to look simple so that we can say, hey, I got everything in one piece of paper. You know, people will do that all the time. They say, I want this deed, I want this ladybird deed, or I want this quitclaim deed because I want my estate plan to be reduced to one piece of paper. Well, guess what? Those things result in complicated results that cause all kinds of harm, all kinds of taxes, all kinds of problems when we're trying to make it look simple, but we're not worried about having the results be simple. What actually happens when you become incapacitated? What actually happens when you die? And so my point is, I think we're better off to say yes, all of the above. Why don't we just say, we can decide this, and this is great for you because you don't have to decide this. We could have all three of these options, including the outright beneficiary designation. So, and this is one of those things we're going to have to do some training and education for some of our financial advisors, because some of our financial advisors have been taught for so long that we just do the outright distribution. We just do a direct outright distribution. But this shows all of these options where we can have better tax advantages, pay less to the government, have more control and more options and more money go to the family, and still have some protections for nursing home and all the rest of that. And we have all the options. And guess what? You don't have to decide. That's the best part of this. You don't have to decide. It's not, because how can you? I can't decide. If you come in and say, okay, Bob, I'm seeing this chart. Which of these, show me the path that we're going to follow. And my answer now, and it couldn't have been this way before because they had all these extra rules about life expectancy and all that. My answer now is yes, all of the above. Let's not make this decision now. Let's wait until we know the facts, know what's going to happen, and now we can make the decision. Because isn't that smarter? You know, I always often compare legal stuff to medical stuff. And so if you were had a stomach ache and you said, okay, well, I guess we could, you know, cut open the stomach and, you know, pull stuff out, or or we could take an antacid. But I just want, you know, in other words, of course, that's silly. I'm using an extreme silly example to prove my point that it's better to make decisions once we know the facts, right? Once we know the information and say, okay, you know, we may find out in a medical situation that there are options, and like we could do surgery or we could not do surgery. But now once we have the facts and say, well, here is what's happening. There is a tumor, or there's not a tumor, or there's whatever. Now we can make a choice, and we can choose to go one direction or the other, but it's better to make that decision once we have additional evidence, once we have more information. And the idea here now is we're going to be able to make this so that we don't have to, you don't have to make this decision. And ideally, we're setting this up so that you're not pushing it on your kids to make that decision. This really does make it so you need good advisors. You need good people that are going to be there when you die, when you become incapacitated, and that's always been our job. That's what we're here for. We're here for, yeah, of course, we're here to help you set things up, but our goal is to be here when you really need us. Yeah, great, we help you sleep better at night because you got things set up good. Well, really, the goal should be, and what has been my philosophy is, this is why we do our annual meetings, and this is why we, you know, stay in contact. This is why we're not doing these webinars and things like that. And we're gonna, I think, in the future now, we're gonna be able to do a lot more of this stuff to reach out to you guys. But the idea is, once we have a client, we look at it as, our intent is that you're gonna come back to us when the thing actually happens, when the bad thing actually happens. There's some kind of medical crisis or there's a death. That's when you really need us. And so the idea is now we get to choose. And so we say, okay, oh my goodness, in this plan, because we chose this path instead of this path, we're going to save $100,000 in taxes under this scenario. And you know, it depends on what you have, it depends on everything else. But I'm not saying, I'm saying that that's a significant possibility that there could be significant savings. And so sometimes people think that because they did the plan back in 2012 or back in 2019 or whatever, that's making it so their family can just, you know, flip a switch, and so you died, you click your fingers, and now everybody walks home with a sack full of cash and everything's good. No, of course we're making it easier. We're making it so you don't have to go through court. We're making it so you don't have to have lawyers on every side. We don't have to go through this probate process. We don't have to extend it out for the period of time that it would normally be extended out. But we still should follow this process. Why? Because number one, you don't want the person you put in charge to be liable for anything. That's really important. That's always been the case. But now under this tax issue, we want to make sure that we can get more money to the government. And so is it worth it to hire a lawyer to say, especially one that, can make sure that we're going to make it easier for the family? So is it better to say, okay, yeah, I thought maybe by doing this plan in 2017 that we wouldn't need a lawyer after I die? My answer is no, we're trying to make it so that it's easier, of course, but the lawyer's still going to be able to help you make these decisions so we get more money to the family quicker than we otherwise would, and make sure you're not putting your person in charge in a tough spot. That's the thing that I want to make sure too, that you're not putting that executor or trustee or personal representative in a tough spot where they could become liable. And that's why we're here. Okay, so yes, we're putting off the decision, but then we're making sure that we have all those decisions available. Hopefully that's a little clearer. So then we've got this issue about, okay, how do we make decisions after death? And so now we have a death. Is it going to a spouse? Do we have the options of having a bypass spouse? Does it make any sense to do that? Can we make that decision? Can we give the spouse that decision? And so can we say, okay, one spouse died, can we leave it up to the spouse to say, spouse, do you want to be bypassed? Because sometimes it makes sense for them and say, okay, well, if we're going to save this much more in taxes, if we're going to do it this way, then yes, it makes sense. Or no, we're going to have it stay with the spouse. Probably going to be most of the time we're going to have to stay with the spouse, things like that. Is there a minor child? Can we get it to a minor child? What if it goes to your son who is very successful? What if it goes to your daughter who's a physician and is already in the highest tax bracket? Is there a way that we could bypass that daughter, or let your daughter, who's the physician, decide that she wants to be bypassed so that it could go on to her kids and save a bunch more taxes and pay lower taxes? And the answer is yeah, if we have all of these options in there, but we don't have to decide that. That's the best part about this. We don't have to decide it now. We get to decide it at the time that it makes sense to decide it, when we actually have the facts involved here. Okay, so this is, I know I get really excited and passionate about these things, but when we have an option so that we can actually do better planning and not have to decide everything now, but to decide it when we actually have the real facts, it's exciting to me. I think this is going to be great. Now, the issue is your documents need to be updated. And so again, if you don't have retirement accounts, you don't have anything that's a Roth or an IRA or 401k, or sometimes people don't even realize they have retirement accounts because they had it as a 401k and they rolled it over into an annuity. Well, if it was rolled over into an annuity, that's a retirement account. They might call it, there might be an IRA that's a CD. You say, well, that's a CD, but it's actually also a retirement account. So that's the thing people don't understand. Sometimes they say, oh, well, that's an annuity, or that's a CD, or that's a money market account or whatever. Any of those things could be a retirement account. It's the nature of how it gets taxed. And so it's not the name of the account. It's kind of difficult sometimes especially when we're doing training in the office and I'm training the team and the staff, and they'll say, but this one says it's a CD. And I say, well, that's not enough information. We need more information, because just because it's a CD doesn't mean it's a retirement account. We have to figure out how it's going to be taxed. And so the bottom line, and this has been a broken record here, but the bottom line is that we are going to now have the option to build it into your document that says you don't have to make all these decisions. What we're going to do is build in every option available, including disclaimers, including what we call accumulation trust, conduit trust, have it go to the spouse, have it not go to the spouse, have it go to separate share trust, have it not go to separate share trust, have it go to the grandchildren, have it go to great grandchildren, have every option available, and we get to make that decision at the time that we have additional facts, additional information. Now, are you pushing that off onto the next generation? Are you putting a burden on your child? Not if you make sure they also have good advice, good financial advice, good legal advice, good accounting advice, but particularly, if we're involved, we're going to make sure that they get that good advice. And so it is one of those things you might have to mention to your family to say, look, just because, and we're going to do a lot of family education. We're going to really shift gears a lot and try to educate. We've done lots of things to try to educate our clients. Now we want to try to educate the family. The trouble in the past has been, well, it's difficult for the family to come in and sit in our crowded little conference room and get educated on this. Well, one of the things with this whole virus thing is we've learned how to do things remotely now. And so the goal, and this is going to take a little time, this isn't going to be overnight, but the goal is to be able to educate your executor. And if they can't sleep and they're up at 3 a.m., they can get some education from us at 3 a.m. on a Tuesday or whatever. So we're going to work on that, and we're going to have all these different ways to make sure that folks are going to be able to get educated. Bottom line is, they will, if we set it up this way and have all these options. We don't want to make it harder for you, so you have to make the decision now. We also don't want to make it harder for them. Yes, they will have to make a decision at that time, but we want to make sure that they understand that they should get, and it'll be worth it to get good legal advice at the time. So now we have 20 options available to us. We got to pick one of them, but now we have all the facts to be able to pick the best one, and that's sort of the exciting part of this. Like I said, this webinar was about the why this is important, why this is a big deal. In the near future, if you're our client, we will be educating you on how. What is the process for you to make these updates? Savannah's going to talk to you a little bit about sort of the next step. If you want to jump in line and make sure that you're one of the first ones to deal with this, and you're a client, she's going to talk to you about that. But even if you're not a client, she's going to talk to you about the next steps for making sure that you can get in a review with us. So we expect that this is going to be an issue because we put so much time and effort and study into this, that we're going to make sure that we're taking care of our clients, but we're also probably going to see that a lot of other folks that their advisors, either they don't have advisors or their advisors are not as up to date on these issues, are going to want to come our way and make sure that we can build this into their situation so that we can get the best results for them. And again, it's not always what looks the simplest. It has to be what actually is the simplest. And the simplest answer is to make good decisions when you have good information. And we don't have that now. So we shouldn't make all the decisions now. We should have all of the options available and allow the people that we love and trust to make the right decisions with proper advice. So I'm going to see if we have any questions here. I don't know, Savannah, if you've gotten any questions, and if you haven't, we'll deal with that. Otherwise, I'm going to have Savannah take over, and we'll give you some instructions here.
Thanks, Bob. So we did have one question pop up during the webinar. Someone had lost connection for a moment and just wanted to know if this webinar is recorded. And yes, it's definitely recorded. We will be sending out the replay tomorrow. You'll get an email. You'll be able to access the recording right away, watch it as many times as you need, and you can also send that recording to friends, family, or anyone who you think could benefit from learning this information. If you do have a question, I do encourage you to go ahead. This is last call for questions. You can go ahead and put that in the chat box, and we'll get to you before the end of today's webinar. Now, as Bob mentioned, we do have an easy way for you to begin working with our team and sort of get in the front of the line for these updates to accommodate for the Secure Act changes. I just sent an email to you a moment ago, so you should have that fresh in your inbox. Inside of the email, there's actually a button that you can click, and it'll take you to a form where you can just give your information. Now, I know we already have your information, but this is separate, and it's keeping it together with the Secure Act so that we know exactly when to talk to you and that you're interested in moving forward, or at least learning the steps that it would take for you and the options that might be available for you. So that email should be in your inbox now. You can read a little bit and then again click if you would like for us to go ahead and begin working on this for you, or if just learn more. That option is there for you. So again, tomorrow the webinar replay will be sent out. That's all we have today. I don't see any questions snuck in the chat box, so we will wrap up. I look forward to seeing you again next week, and I hope you have a wonderful day. Thanks, everyone.